After listening to 7 days of trial testimony, the jury deliberates for 90 minutes, awards an 85-year-old companion caregiver a grand total of $323,700 in damages for emotional distress, and 0 to the daughter who had used her father's power of attorney to file the lawsuit against the companion caregiver. I'm John Roberts, an estate planning, probate, and elder law attorney for people in Springfield and Hampden County, Massachusetts. If you have to step up and use power of attorney for someone, make sure you're using the document as a shield to protect the person who is under a disability, not as a sword to promote your own interests. The jury deciding this California case was asked whether daughter's conduct was a substantial factor in causing companion caregivers severe emotional distress. The jurors checked yes. Had the companion caregiver proved by clear and convincing evidence that daughter acted with malice, oppression, or fraud? Again, the jurors checked yes. It was an extreme case showing how care and compassion are always required.
I hold power of attorney for a member of my family. What can I learn from this case?
Be careful if you're thinking about using power of attorney against someone. The Court of Appeal upheld the jury verdict because daughter and her sister knew that companion caregiver, who was in her 80s and had recently suffered a stroke, was emotionally dependent on her caretaking role for their father, and had been his sole caretaker for a lengthy period. The companion caregiver had no legal or practical ability to interfere with their father's finances because daughter had taken over. Here are questions you can ask yourself when using power of attorney.
Could the actions I authorize cause harm to someone else?
The evidence showed that companion caregiver had become emotionally devastated by her inability to see and care for the gentleman. Further, the sister's conduct was not a momentary lapse and instead was the product of deliberation and discussion that continued over a 9-month period, from the time the sisters refused to disclose their father's whereabouts through the time of his funeral.
Are the actions I'm taking in the best interest of the person I'm representing? Or are my decisions based more on my own interests and convenience?
The court concluded the sisters made the decision to preclude the companion caregiver from seeing their father and from attending his funeral to punish her for her actions that reduced the value of their inheritance, and were fully aware of the devastating impact the physical separation had on the companion caregiver.
Should I be afraid to use my best judgment on behalf of the person who asked me to serve with their power of attorney?
Don't be afraid to do the right thing. Courts won't second-guess you or intervene where someone's feelings are hurt or when people simply express an unflattering opinion. We all need a safety valve so irascible tempers can blow off relatively harmless steam. But the California court judges said the daughter's role as trustee and attorney-in-fact did not give her the privilege to treat the companion caregiver as she had. The caregiver's compelling testimony about her devastated condition in not being able to care for the gentleman in the last months of his life, and her humiliation and pain in not being able to say goodbye at his funeral, supported the surprising verdict.